second.
Okay. Oh, there it goes. Give it a sec.
There we go. Thank you, Brett.
Yeah, no problem. Thanks, Jennifer. Again, so as Jennifer said, I'm Brett Hilberry. I'm going to turn off my video here in a second. I just wanted to give you all a face for good or bad. This is it. And I've probably worked with a lot of you over the years, but and I think there's a lot of Vision Housing people on here, so obviously I've worked with them. But I'm Brett Hilberry. I'm the Environmental Compliance Officer for the office, and I'm going to do a pretty high-level review today because a lot of this stuff, while it applies to the grants that you're going to receive, is work that I wouldn't suggest you're necessarily creating for yourself, maybe using somebody else. But I'll talk through a lot of the things that will impact you, timelines and things like that. So I'm going to turn my camera off and start sharing my screen so I can share a few different things. Jennifer, I don't know if you sent out that agenda yet, but I'll throw it on here briefly, just a second.
That would be great.
Share that screen. Okay, can you see that, Jennifer?
Not yet. It might be taking a moment to share still.
There it comes.
Perfect.
And that's part of the reason why, everybody, I want to just take myself off the screen so I can save bandwidth and move quicker. So I am going to hide myself. And I will get going here. So the agenda is pretty simple. I find that that questions are often more important, especially for the group that's on the phone, because a lot of the questions that you'll have are probably ones that others have because of similar situations. So I'm just going to get moving through this. Hold on, I'm reading Allison's. Okay. So I was on a training yesterday, actually, for a very similar thing. It was an in-depth training, but HUD was putting it on. And it goes through a lot of what I'll be real briefly hitting on here today. So I'll try not to just read from what I have here, but I will be moving backwards and forward to 3 different website tabs that I do have, or there's 4 here. And which you can't see those either, can you? Hold on, let me pull those over. Give me 1 second. Okay, and I'll pull those over as I need to. But on the second page of this document, there's links here of things that I'll be showing you. Very basic links, one to our webpage, and then a couple other to some HUD pages that I'll pull up as needed. So what is a Part 50 versus a Part 58? Stuff that, again, you might not care too much about. The Part 50 is what is the federal regulation referencing what HUD's, when HUD's responsible for completing environmental review. So that happens with sometimes HAP contracts, which I don't believe this is that group that would be on here with those, but some of those go through and are cleared by HUD under a Part 50. A Part 58 is where HUD's giving me the authority to complete on behalf of HUD, so I'm somewhat of an extension of HUD, to confirm compliance on environmental reviews. Obviously, if you're on this call, then you're either CDBG, home, NSP at some point, and other, I don't know what else there may be right now. And there may be somebody with a housing trust fund or that have received housing trust funds on here. That's a little bit different, but they still have requirements that are fairly similar, but it doesn't fall under this Part 58. But I'm still required to confirm compliance on those as well. So for purposes of this, I'm treating this as a CDBG home project project requirement agenda. So the responsible entity, briefly, that's me. It could be the county, it could be the local government. HUD recognizes local governments. They don't recognize housing authorities as local governments. Therefore, a responsible entity is required to confirm compliance on behalf of a project. So anytime you're just receiving Division of Housing funding, we are the responsible entity. I'm the certifying official on behalf of the responsible entity, but the responsible entity is my Department of Local Affairs. So that's what responsible entity is. You may hear it. That's the only reason I put it on here is because you may hear at some point that there's that you need to have the responsible entity do something. Well, if it's just Division of Housing giving you funding, then I'm the responsible entity. If you're getting funding from a county or a municipality, then they're a responsible entity, and there could be multiple responsible entities on a project. So just think of it as that. In no case can a nonprofit or a developer or a housing authority be a responsible entity. Now, level of review, and this is where I'm going to pull over my web page, which is one of those links. I believe you can, yep. So this is the web page that, for good or bad, is what we have, and I'm looking to, over time, I'm looking to improve it, as many in Division of Housing probably can attest to. I've been saying that for quite a while, but it's on the list to do. But if you go into this, this has 4 levels of review that are quite common. Exempt, CENST, which is called, why am I drawing? Categorically excluded activities that are not subject to specific regulations. Stuff that you don't it really doesn't matter for this high level type of review. And then you have a CEST, which is categorically excluded activities, but they're subject to more federal regulation. And then you have what's considered the environmental assessment, that I'm sure everybody who's on here that's had one is what you don't really want to do, but that you're going to have to do. And that is where all of the federal regulations are required compliance for them. So the 4 different reviews are exempt, which count for things like pre-development, admin, studies. You can do those types of things quickly at the very beginning of a project. That CENST, categorically excluded, not subject to, are for things like rental assistance, maintenance activities like changing light bulbs and things like that we could pay for maintenance projects on a facility. They don't require a very difficult review, but you got to make sure if those things are tied in with more significant rehab, then you just have to consider the whole thing as rehab, and you can't consider it as maintenance. But these are things, and then down payment assistance is another one for CENST. With any of those, please work closely with your developer. They're pretty aware of this stuff, but if not, they can reach out to me, or you can reach out to me at any time to ask the question whether or not something is maintenance only. But this calls generally for CEST, multifamily, CEST, categorically excluded, subject to, or environmental assessment. The CEST level review, to keep in mind when you'll need to do different ones. I believe at least there used to be in the award letter what the environmental review level would be. If not, your developer usually will have a pretty good idea early on in those conversations. But a CEST is if you're constructing 1 to 4 new houses or 2 duplexes, it's units. So 1 to 4 units of new construction, or most rehab projects, as long as you're not increasing density, meaning you're not going from, say, 4 units to 6 inside of a 4-unit building, and somehow you determine you can create 6 units in the same building, then anything, as long as you're not increasing density, then CEST is generally what you'll need to do, which is on that website that I just showed. As for the environmental assessment, when it gets more difficult, there's the 14 regulations that you have with CEST, which is that statutory checklist that a lot of you have maybe seen over time. And actually, while I'm going through it, why don't I just show you that so I'm not speaking about it without you being able to see it. So the categorically excluded subject to would be, let's see, I'll use our version. So this is called the statutory checklist. It's the various regs that are required, and this helps you determine whether or not your project fits this CEST requirement. And then there's the 14 regulation, and please try to look past the yellow for purposes of this phone call. These were places where I was really trying to show that there's specific things that take some time, and this is why I highlighted a lot of these things. But these are the 14 regulations in what's called the statutory checklist. It's for small projects, it's not that difficult. When the projects get to be 4 units and then more, then it obviously becomes more difficult, which gets us into the environmental assessment. Well, this is when you have 5 or more units. So you're talking about, this is generally where you'll be living, multifamily housing, which is for new construction, 5 more units, or if you're doing that rehab, if you increase density beyond 20%. So again, if you go from 4 to 6, then you're going to have to do an environmental assessment. You go from 4 to 5, you're on that threshold. I suppose you would have to maybe do it there too, but it's 20% threshold. But generally, anytime you're multifamily, unless you're doing just rehab without increasing density, maybe just doing painting and floors within a multifamily apartment complex or something, then you're going to need to go in and use this. This is for major rehab and new construction. And again, let me pull up that. What goes into the environmental assessment, different from the CEST, is that there's that statutory checklist. It's the exact same thing that I just showed you with the CEST, but I'm pulling it up here just a second. But it also includes what's called the environmental assessment factors. And this is where the beginning of this is a little bit different. It asks for a lot more detail of what the project is, because the impact of that project by HUD's perspective is that it's going to be much more significant on the impact of the community. So it asks for a lot more information, but you'll see as you go down, it's the same statutory checklist which is included in it. And then once you get past that, there's these environmental assessment factors. The purpose of the assessment checklist here, this environmental assessment checklist, those factors, is that it's trying to assess the load the project will place on the community. So it wants to make sure that there's the infrastructure that's currently in place can manage the load of the, from an easy perspective, say it's a 100 unit apartment complex, the new load on those units that will place on the local infrastructure of fire and water and sewer and schools and transportation. These are the things to say to allow a project to be assessed to determine, well, is this project in this location the right place for this? Because if they don't have these things in place, for instance, if the water system can't manage to bring on an additional 100 units, which could be 300, 400 people, then maybe this isn't the right place. And that's the purpose of these factors. That's why they exist on this versus the other one on the CEST, because the CEST, since it's 1 to 4 units, the assumption is you're not bringing in a brand new community by creating this. But with multifamily, you often are bringing in a significant load to an infrastructure that may not be able to manage the load. So those are the reasons for that. That's the difference between the two. Like it or not, that's the purpose of those. So the one other thing I wanted to point out under this on the agenda, the phase 1 and 2 EA versus the Part 58 NEPA environmental assessment. Anytime somebody speaks with me about environmental assessments, I try to make it as clear as possible that I'm talking about what's considered a CFR, Code of Federal Regulation, 24, Title 24, Part 58 HUD environmental assessment. And I often refer to it also as a NEPA, the Environmental Protection Agency or Act environmental assessment. Those are very different than what a phase 1, obviously, and a phase 2 are required for securing a loan or something that you all go through. But what happens often is that they both use the term environmental assessment. So the only reason I'm bringing this up is I want to make sure that you're aware early on in this process, if you know you need to do an environmental assessment, you need to probably do a phase 1. And if that determines you need a phase 2, then you need to do that. But that is not the same thing as what's required to secure these home funds or the CDBG funding. You need to do that plus this Part 58 HUD NEPA environmental assessment. So I want to put that out there because sometimes I'll get a phase 1 in the mail or on an email saying, do we need to do anything else? And I'll say, yeah, and there's a lot you have to still do. So the next little piece here is I guess, let me just see, does anybody have questions? I'm going to answer questions at the end, but if somebody has a question we can answer real quick, I'm happy to do so. I don't know if there's any in here, but I think unless anybody points anything out to me, Jennifer, I'm just going to keep moving.
I think we keep chugging along. We have no chats in the feature.
All right. So the next section is just, okay, so you're thinking about applying to Division of Housing funding. As you all are aware, and I'll allow the developers at some point to speak more about this with you, but what I've learned over time is that when you apply to Division of Housing, you are applying for whatever available funding source is there for you at the time. And I'm not saying that's true in all cases, but generally that's the safest bet. Therefore, anytime you apply to our office, you should consider that the project's going to become federalized because it's going to receive some sort of federal support from a grant. So if you're considering DOH or other funds, and what I mean by other funds is if you're applying to the city and county of Denver, or if you're applying to Arapahoe County or Jefferson County or Colorado Springs, if you're applying to them, they may be providing some sort of home or some other source of funding as well. That federalizes your project as well. So early on in this process, consider whether or not you need or are going to be requesting Division of Housing or other funding from other local governments. And then start to determine or start to put in line the things that you know will be required. And I've spoke with a lot of different grantees about this and Division of Housing staff is that you need to really be prepared to budget for it, because if you get federal funding, then there are going to be associated administrative costs that wouldn't exist possibly with state funding or some other funding that doesn't have these federal requirements. So while a phase one is likely required in many cases, so you're probably budgeting for that anyway, and if a phase two is required for that phase one, then you're going to have to do that regardless. But engaging a Part 58, so engaging a HUD professional, Part 58 consultant, is often what I suggest because time is money. They can move the project forward. I think over time, over the years, once a grantee's come in for some funding on maybe one project and comes in on another, they've gone through this once and are like, we're going to go ahead and just go out and get somebody, and they know that. So they're early on budgeting for that. I can't give you like a specific number because there's a lot of options. But when you're out there, when you're doing outreach to hire a consultant, and making sure that they're talking about a Part 58 HUD environmental assessment, and that when you're asking for their services, you're not just saying a phase one. Some companies can do phase ones and phase twos, as well as Part 58 HUD environmental assessments, but I think the majority of them do not. If you're doing a phase one or phase two environmental assessment, that's an environmental firm, but it's not necessarily the same firm that would complete a Part 58 environmental assessment for HUD. I'm just letting you know that. So you may have to make a call to a separate place than the phase one company that you used. But engaging a Part 58 consultant can be $5,000 to $8,000, and it really does determine. It is based on the scope of your project, likely, maybe the backlog of the company. So I would suggest always reaching out to more than one, and then in all cases, always asking them to ensure that, or ask if they've ever worked with me before. There's a lot that goes into that, a lot of work that I've done with consultants over the years that they know exactly what I'm looking for. Have them reach out to me if they have questions early in the process. These are the types of things that you should bring up when talking to a consultant. But you should budget for $5,000 to $8,000 there. Another big issue that comes up with consultation as part of that statutory checklist that I was showing you, that again is in both the CEST level, the 1 to 4 units, but it's also a requirement in the EA level, in the 5 or more units, is the historic consultation requirement. And I'm not a archaeologist. What I consider myself is I'm a generalist. I know I'm pretty informed about all of the regulations, but I'm not an expert on any. I don't have certifications in any, no qualifications to be able to provide the necessary information for, say, contamination, or I don't have a background in floodplains. I don't have a background in a lot of these things as a historic professional. But I can somewhat give them enough information on most things to make sure that we can move a project through. One of the things that I do not have the certifications or the knowledge to perform and help with that very much is the historic consultation piece associated with the project. So I can tell you whether or not we need to consult, because we do have a programmatic agreement that for anybody that's a returning grantee maybe on this call, you may have utilized the programmatic agreement in the past, and you may or may not even know if you've had a consultant hired. I would have worked that out with them. But in cases where that programmatic agreement doesn't apply, which would be a new construction on undisturbed ground. In almost all cases, you'll have to consult with State Historic to confirm under what's called Section 106 consultation. And the Section 106 is a regulation specific to State Historic and Historic. The Advisory Council on Historic Preservation is at the top of that. I won't get too off on that, but just understand that it is required to engage a historic professional when necessary, because we need to make sure that we're providing our State Historic Preservation Office documentation relevant to the project that only in certain cases a certified professional, an archaeologist in some cases, can provide them. So budget for it. You may not need it based on if programmatic agreement applies, based on if it's a newer building maybe that you're just doing significant rehab on. That may be an environmental assessment level review, but the building may only be 20 years old. I mean, I've had a few of those recently. Well, that doesn't require a State Historic consultation, because our programmatic agreement allows us to avoid consultation on younger buildings or younger homes. But engaging a historic professional, again, could be $5,000 to $8,000. So this is the high end of budgeting for it, and then you can always hope that it's less. So in all cases, be prepared for $10,000+ of potential costs in your budget, and that's outside of a phase 1 and phase 2. One other thing, when you're considering a DOH funding or other, and you're asking for it, and you may end up getting some sort of federal assistance, is there's this choice limited action. I'm sure I see Wayne on here. Wayne's probably had this conversation with many of his grantees. I've had this conversation with many grantees. On occasion, this regulation has resulted in a grantee not receiving funding. What a 5822 choice limited action is that you've, and I have the definition on page 2. I'll just come over to that definition. And then you're going to get this agenda, assuming that you haven't already seen it. So you can look at this. But basically, it's a prohibition on choice limited actions, which prohibits any physical activity, which includes acquisition, rehab, construction, as well as contracting for or committing to any of these actions. So things like design and administrative things are not a choice limited action. Those are an exempt activity. So while I was showing you those 4 levels of review, we need to confirm that and complete a quick exempt environmental review, which I show here, and I'll talk about in a couple minutes, but that only takes about 10 minutes. It's very clear. It just shows that in an audit, HUD will be able to look at what we've done and say, you guys know what you're doing. We don't feel that it's necessary to dig further into this program to confirm that you're not making a bunch of mistakes. So you can do things like that. You can hire for design, and you can do those types of things. But any type of transfer of ownership cannot happen after you've applied. There's that separation. HUD's they're pretty clear on this now, on how this works. If a grantee already owns the property prior to applying to either our office or to another local government that's providing the funding, that application is considered it federalizes the project. So the minute you apply to Division of Housing, you can't do anything with that property, including a purchase and sale agreement. You cannot have those, even if it details requirements that are necessary. In a purchase and sale agreement, I've seen them to where they have a purchase and sale agreement that states it's contingent on a successful environmental review. Not allowed. You cannot have a purchase and sale agreement. And I'm going to go roll back up here, and this is where I jumped into the next section, because I didn't want to read through that choice limited action, because I figure you can ask questions if you want, and you're going to have this document. But avoid purchase and sale agreements, but you can have option contracts or option agreements. I don't really have one prepared for you. I think I would always say speak with your attorney, or maybe see if there's a template out there for an option contract or an agreement. But all that tells you is that for any reason, as a grantee, as a future developer, you can come into a property, you can lay out this contract, this option agreement, but the agreement basically states, for any reason, we can walk away from this property. There's no dates, there's nothing. All right, you can put into that option agreement that you're working on an environmental review, but that's not the reason why. You can choose to walk away because you don't like the owner of the property for some reason. Now, with that, you can also put down a in good faith offer of a a minimum amount of money as a good faith gesture, and that dollar amount can vary. Say it's a big property for millions of dollars, you could maybe provide $100,000 in good faith and say, here's a small amount of it to show that we're really serious about that. But the option agreement, and you can't get that money back, by the way, but an option agreement allows you to walk away. The assumption for HUD is that you can afford to give that minimum amount of money to them to give them good faith. They believe that you're truly going to go forward with this if they're going to do this option contract agreement with you. But they don't want you to put so much money into a property that ultimately maybe comes back with a bunch of contamination issues that would require $2 to $3 million in mitigation, and all of a sudden you're locked into a property you can't get out of, and now it's not affordable for you, and you're stuck with it. So understand, one of the things, and I'm scroll back to choice limited action, this is the basis of everything you're doing with HUD surrounds this choice limited action. They want a developer, a grantee, a nonprofit, whoever, they want you to have every alternative available to you to walk away from a property because you have all these federal things that need to be taken into consideration. They want you to also look at the findings of all that, everything that you see in that environmental review. They want you to take a look at that and then determine whether or not it's the best option. It's very rare that I have a grantee that's looks at an environmental review and after the fact says, you know what, that isn't the right option for us. But that is the purpose of it, because historically, before a lot of these regulations maybe were applied to these funds, people did shady things, put low-income housing in places where it shouldn't be, either contaminated areas, places that have terrible air quality because they're located right off of the busiest possible highway, in the state, things like that, which, cause significant issues. And so they had to start implementing all these regs over the last 20 to 30 years, to make sure that people are doing things that are morally good. So while this burden exists for all of you when it comes to receiving funding from Division of Housing, that's the purpose. And the choice limited action is basically saying, we need you to be able to follow that purpose, to be able to walk away from a property for any reason. Otherwise, if you don't do it after you've applied for these funds, then you would be limiting the options to the available options on that property, and you will not receive funding. There is no option around that. So please just be very careful on that. The developers hear it from me a lot. Anybody, and I know that sometimes Division of Housing has new staff coming on. Hopefully some of this helps. But please always reach out to me if you feel that you're not sure. It's better to have the conversation in advance to determine whether or not this is an issue versus doing something that you can't walk back. So that's choice limited action. I get a lot of questions on that. So, and also, please feel free. Don't feel that I'm off limits to anybody to reach out directly to. I think in a lot of cases, developers and asset managers, especially on rehab projects, they know what they're talking about. And so I think they can answer some of these questions, but I'm always available. Jennifer's going to send out my contact information. I forgot to include it on here, but you can reach out to me at any given time. So again, considering Division of Housing funding, and the thing that I run into a lot are people setting deadlines. Do not set tight or unattainable closing deadlines. I can't speed up the environmental process. And to be quite honest, it gets difficult and somewhat frustrating when I'm trying to help expedite something where there was a date set up that I'm trying to help hit, but it was unnecessary to be set up prior to knowing the official timeline, because I can't control these. There's a lot of deadlines that go into this. There's consultation requirements that are 30 days at a minimum. There are publication requirements that are roughly 23 to 35 days. We can't get around these. So you have roughly 2 months of this process, especially for environmental assessments, that we can't get around, regardless of how fast a lot of the other work can move and how quickly we can complete these checklists and these forms. So it's very important to me that you do not set these deadlines. because the busier I get, the less able I am to move these as quickly. And right now I'm extremely busy. So it's just easiest if you keep those as far down the line as possible, or keep them flexible, and explain all of this to whoever it is that you're working with to close these. And I get that in the real world, it doesn't always work that way, because you have other agencies that, I hear this a lot from CHFA, that you have CHFA deadlines you're trying to hit. But again, this is why I'm saying think about it early on in the process of applying. So just real quick to that, the length of environmental review for each of these various levels are, I just made this up for an exempt, because honestly, the exempt form can be completed and signed off on by your developer, by your asset manager. It doesn't require the certifying official, which is me, because we're not certifying anything to HUD. All we're doing with that document is showing that if we get an audited folder and file for a project, that that we know what we're doing, and that we've considered this as part of the step process, which ultimately may get to a project where you need a full environmental assessment, but we're doing the design, we're doing the admin, we're doing stuff, and we're just doing it. So I said 10 minutes, it could be 1 minute, it could be a little bit longer. It all depends on how often you've done one of these. The CENST, I said 30 minutes, it could be quick, depending on if it's supplemental assistance for previous project, which I didn't bring up, so I apologize for saying that, because now that just would have confused things. But you know, for DPA, you have to, down payment assistance, you have to throw on a floodplain map. So that could take a few minutes. So there are a few things that can hold that up. But then you get into those two that apply to multifamily in most cases, or CEST, is 45 to 80 days. The reason I say that, because a CEST, if it has to be published, which I won't go into all the reasons why it may have to publish, there's sometimes they don't, but there's oftentimes they do. If they have to publish, then we have at a minimum 7 plus 15, so 22 days. You take into a weekends, probably a minimum of 25 days worth of publication. So that number's involved in that, regardless, and that's separate of the requirement to consult with State Historic Consultation, State Historic Preservation Office. It could require tribal consultation. These are 30-day consultation periods that usually you can't get around unless our programmatic agreement applies. So these are the 45 days for CEST. For an environmental assessment, you're looking at 90 to 100 days. That's why, to me, it's so important that if you're considering things, there's two things that I think you should most be aware of. Budget for whatever may be coming with that funding, and know your timeline. And if you're going to do an environmental assessment, if it's new construction, you're going to be in this EA environmental assessment, HUD Part 58 environmental assessment area, you're looking at 90 to 100 days. On the training I did with HUD yesterday, there says 100 to 120 days. So they actually think it could be longer. I historically find that we can get to 90 to 100 days. Things that could hang that up are like anything where you demolish a building early before you've got all the permissions. Wayne and I have been on a project for this like that before, where demolition occurred, and while everything on that environmental checklist was okay, State Historic Preservation Office felt that we foreclosed on their right to consult. It delayed the project 6 months because we needed to go through and do all these mitigating factors, because we didn't give them the time to consult on the property prior to the developer demolishing some buildings. That's an example. So in that case, we're looking at half a year. So 90 to 100 days generally, if you follow everything and don't do any choice limiting actions, is how quick we can do an EA. That's kind of the high level on everything. I could go into each reg, but I don't think that's for everybody who's on here. And more importantly, if I go to my training material links down here, there is, if you use the Wiser module trainings, if anybody wants to know more information than they ever needed, and I don't think there's a whole bunch of people on here that probably want that, but if you wanted to, you could go to this HUD Exchange trainings. It's a Wiser module. These are specifically built for those that have some connection to this. So like, this is a getting started with Part 58. This is a quick, high level, more in depth of what to expect from this HUD environmental Part 58 process. So you could go into these, you could look and get into each individual factor of all those of the statutory checklist, historic preservation, and each of these are trainings that go through all this detail. So I have no reason to feel that I should show these because these already exist on there, and they'll be on the sheet that I send you later. So again, I can answer questions about any of these. I could train on these, but these are even better and more in depth. So that's one of the things on my sheet. And then the other one is this other link here. This is a this would be a good link. This would be a good link if you just want to remind yourself of what the heck this process is. This is the HUD website, and this is kind of a high level. You can click on each of these links. Like, what the heck is this? What's the overview? What is this environmental review thing? What's a Part 5058? What's the timing of review? I kind of went through all this. You know, what is a project description? What should it be? Again, that should be up to your consultant to work with me to make sure that that thing's nice and thorough. But if you're trying to do it in-house with your staff, which does happen on occasion, at least the first time, this is a way to explain what you should be putting into that. And then here it has the level of reviews and a bunch of other things. Okay, so this is a really quick, basic way of looking at the various things, the various levels of reviews, and it gives a little bit more detail. And within this, they also have these other documents that I don't have open here. Give me 1 second. It's the here. And then I'll go to questions. But just for you, so you understand what's in this document that you'll have, is that there's this corn chart. I apologize. I have no idea why this thing is a corn chart. It existed years ago. It's supposed to show the way things grow, I guess. But you'll see it talks about the deadlines. It kind of hits on the stuff that I just said, but it could just be a brief reminder. I know Allison O'Kelly used to have it on her wall next to some cool pictures. And then there's another thing on here, environmental review process. This is the step process. I hit it at a high level. You can kind of go look through what is it that goes into all the things that get me to that 90 to 100 days, depending on the level of review. This is all something that you'll receive in an email, and they're all on this form, assuming I sent Jennifer the right one. That's it. What questions does anybody have? I saw some coming in. Am I supposed to read those? What do you want to do, Jennifer?
So a couple questions came in from Wayne, and I think you briefly touched on both of these. So first was, can we talk more about federalizing projects and the consequences of choice limiting actions? You talked about the purchase to buy agreement. Do you have any other examples that you could provide?
Oh, let's see.
Hey, Brett, could you?
Yeah, go ahead.
Okay, so the purchase and sale agreement, because you know me, I'm kind of detailed, and I thought we had this one covered. We won't mention names since this is a party line, but
oh, sure.
We have one project where we knew that they were going to use home funds from us. We knew they had an option to buy, and everything was good. But then what they did was, without my knowing it, they altered the end date of that option. And they told me they were doing that. I'm like, cool, not changing the number. But when you went through your EA review, you said not cool. So I think that's something that we want to highlight, is that if anything changes, whether it be paper change or whatever, after the project's been quote unquote federalized, they can't do anything until they get a release of funds from us, right?
Yes. Yeah, I mean, there's a whole bunch of what ifs, right? If the project all of a sudden receives state funding, it shifts all of what we've just said. I think here, let me read this. This is recent, and I don't think this is exactly going to answer your question immediately, but recently they've made it very clear at HUD. The defining difference is if you've taken ownership of the property, you can acquire something prior to application to us. And if you really wanted to be what I would consider a potentially difficult grantee or difficult person for purposes of my environmental review, would be you could probably acquire that property the day before you applied.
Yep. Because
per that cutoff, you are in compliance with HUD's current stance on this. I've seen the legal opinion from them. It was a big issue years ago. Wayne and I know about this. I mean, I keep saying Wayne because that's the one I think back to. But
Yeah.
there was a project that required further detail and digging in with HUD, and it went to DC, and we got some information. But that defining line is if they've acquired the property prior to application, then really they're okay. They have to abide by that agreement. It was in place before they applied, so be it. The problem is, as HUD pointed out on the training yesterday, and I think what I've always said to Wayne and probably others, because I've had this conversation directly with grantees and developers, is that HUD could see this when looking at in an audit. And once you start to see that somebody thinks that they're working the system a little bit, knowing all these little dates, well, where else are they trying to cut corners to potentially accidentally try to speed things up? And it just may bring a program underneath the vision of HUD to maybe want to dig in deeper. So I've always said, try to be on the up and up. That could happen, and maybe it just happens coincidentally that somebody takes an acquisition the day before an application. But generally, don't put yourself up against that timeline. If you've acquired the property a long time ago, fine. If you know you're going to be acquiring the property in 3 months, do the environmental review, get it out of the way. And then just be compliant at the time where you're taking acquisition. That's one way of looking at it. For Wayne specifically, for instance, if the purchase and sale agreement was in place prior to them applying to us, then so be it. They already have that agreement in place.
Yep.
Now,
and they changed it.
Yeah, I don't know why you would change it midway. Because, but them changing it would have an impact, because now we would consider it a new contract. Now, maybe they were trying to change it because they wanted to abide by the regs and make sure that they were, following those regs and making sure that they weren't taking ownership too early, which accidentally may have made them potentially violate this 5822 regulation by having a contract now placed in place at that time. But again, that's just a one-off. I hope, Wayne, that we can work through on the side, right?
Yeah. Also, two other things.
Oh, wait, Wayne, before you move on from that topic, can I just add a thing that Brett and I once talked about on this choice limiting thing before? Is that okay, Brett?
As long as it's accurate.
It will be accurate. You and I have had a conversation about that when you were saying if they bought it, like years ago, clearly you can't go back and retroactively do an environmental review on a piece of property you bought 10 years ago. However, if you're planning on buying it soon for this project and you're going to apply for federal funds, why would you acquire it before you do the environmental, with incurring the risk of the chance that you might not get clearance because there are problems with the property that you want to walk away from it? Why would you buy it before you know those things when you have the option to do otherwise? I'm sure I'm not quoting you right, but that was the whole conversation we had about a project once.
Right. And I think, and that goes down to back to that alternatives thing that I was saying a little while ago about the whole purpose of this choice limiting action is that they want to make sure that we are protecting the grantees, those providing and developing and constructing low-income housing. We don't want them to get stuck on a property that ultimately is undevelopable without a significant infusion of funds because of all of these factors that may have violated federal regulation. Just having a property, say, down grade from a couple of gas stations, just having that when you're looking at purchasing a property, that could cause issues. That could result in millions of dollars of needing to remove, soil from the property or whatever. I don't know, it would depend on the size of the property. Just simple things like that could become a giant problem for a project. So it's always good to get all the information before you do any of this. But anyway, yes, I agree with that. I agree with that. What else?
Sorry, Wayne, go ahead. I just figured that was all part of the same topic.
I'm slowing down. I give other people a chance to ask something.
Well, then I will pipe in. This is Lisa with Mile High Development. Hi, Wayne.
Hey,
Hi,
what's up,
Brett.
Lisa?
Hi, Lisa.
Hi. Well, since this whole thing is like very recent on our minds for a project that we're working through now, I'm just looking towards the future. I know we have other projects coming up. So I am curious if, you say to start the EA early. And I think from our perspective, I'm just trying to figure out at what point should we actually go through the formal application process, like with Wayne, that has helped us on other projects, in order to give us time to begin the EA. So I wouldn't necessarily want to trigger that and do it really, really early. I mean, who knows what could happen, from the time that we are awarded tax credits, but we still have to go to that process with CDOH to get the funding and get approval on the funding. So just wondering if you guys could, if there is a timeline or some way we can reverse engineer to hey, when do we need to start, pinging Wayne or whoever's going to help us on, whatever project, get started with a formal application and to go through all that process to get the approval, because we wouldn't want to start the EA until we knew that. Does that make sense?
And I'm not sure if that was specifically towards me or Wayne. I can answer from my perspective, and I take it into almost, I try not to do so, but I take the perspective very differently. I think it's a good question. And my perspective is very different from developers, so I could step on their feet. And I don't mean to, but I know Spencer and I have chatted about this in the past. I know Wayne and I have, and I'm sure, Andrew and I have. It's a pretty common issue, right? We're the gap funder. If there's not another local government funding the project, for instance, if Arapahoe County or Adams County or Denver isn't on the project because they've already informed you that you're doing this, and so they often inform me, hey, by the way, we're doing this environmental and it looks like they're going to apply to Division of Housing, so do you want to join us? Well, it makes sense that you're already going through that environmental because you've already secured from them at least something probably before you've come and really applied to Division of Housing. It's very rare that I'm on an environmental review when an application's yet been submitted to Division of Housing. So if we're just talking Division of Housing funding, it does create some difficulty. The only thing I would say is reach out very early and start to the developers. I think they have a pretty good idea of where funding may land based on the type of project. They can always talk to me if they think if a project seems to fit better. I don't under one type of funding or another, and those odd situations. But at the same time, I always, without thinking of them, say start early, right, Lisa? And you're saying the exact same. Well, why would I do want to start early, but I don't want to waste you're saying budget all this money. I don't want to start spending it if ultimately I'm not going to get home funding or whatever.
Right.
And honestly, that there's a catch within there. I don't know how to get around that. And not to mention, I think in years where we know there's not a lot of state funds and it's at that period where there's only a lot of federal funds, I think it helps to really guide me to know that there's a lot of projects are going to be federal. So when I'm talking to somebody, I can say, it makes sense. Time is money. So if you're already ahead of the game, you're going to save months later on. Is that worth $5,000? I don't know. But I guess for me, it's just, I always will say start as early as you can. Now, when I say that makes sense, it doesn't necessarily make sense for you. I also am getting to the point where I seriously am struggling with reviewing environmental reviews in advance of confirming if Division of Housing is providing federal assistance to a project. So you and I are both kind of caught in the same situation. I think the best thing we can do is just reach out as early as you can to whoever it is that's the developer or that would likely be the developer on your project, and just start the conversation. Worst case scenario is be flexible with your timing. Don't start too early. Be willing to allow the project to go through the environmental process, and you'll have to just close a bit later. I mean, to me, that's the only way to be certain we're not wasting money.
Right. I guess, and then, and that makes sense. I mean, I totally get it. I just, I've seen, we've gone through a couple different projects recently that were, a little bit tricky. One was a demolition type of a situation. We weren't the project that you spoke of, by the way. But Yeah, and we've been through a lot of these things. I like to kind of know more in advance, or I can say, hey, I know we're looking at closing at this particular time, and if I can say, all right, at the 6 months to go, then we should start working with Wayne to, for instance, to start that formal application process. And I guess that's what I was trying to get to. So if you're looking at 120 days or 90 to 100 days, how many more months before? I'm just trying to, if I'm looking at a timeline, because there's a lot of other things that have to happen that are crazy, working towards a building permit, et cetera, that it would just be helpful to know. I could say, oh, okay, we need to start working on this, just to make sure we have enough time. Because I don't like being put in the situation of, just like you don't, Brett, of, hey, we have this closing and we have to close by this date, and trying to hurry everybody up. So what would you say, Wayne?
I was putting a message in. I'm going to send you an email right now.
Okay.
We can talk offline. That way we'll save our time.
Okay. I mean, I don't, and I don't know who your audience is, but we're
okay.
But yeah, that's definitely on my mind, and especially having other projects upcoming, so we can be ahead of the game.
Well, and this is being recorded, so I think it's good. I mean, Wayne, would you at least agree that the best option is to reach out to the developer of who they would assume it may be as early as possible to at least start talking? And that's the first step?
Yeah, real quick, I reach out as quickly as possible, as early as possible in the process. And I also let the Denver area, metro area applicants know that it's easier from a compliance standpoint for us to deploy the actions associated with federal funding that are closer to the Denver metro area. So these projects in my area tend to, first choice is going for federal funding, either home funds or HTF.
Got it. Yeah, so thanks. Yeah, I don't think we have the perfect answer, but I think that helps out with Denver for sure, to a degree. But start communication early with me or whoever. I think that's what everybody, I think, would agree with. What else?
We have a question from Robin. One thing I've heard is that a new phase 1 ESA standard is pending. Is this anything you can speak to?
No, and I am sorry I can't. Because I'm that generalist and not the expert in contamination and that, I just follow whatever the current standard is, but don't know what goes in behind the scenes of adoption of that new standard. Once it goes into effect, hopefully there's a brief period of time where they can transition to the new standard. I hope for my purposes, because I guarantee somebody's going to do it in phase 1 with the previous standard, and then I'm going to have to try to work through whether or not I can accept it. But no, unfortunately, I don't have anything else to offer on that. If I hear something, I'd be happy to communicate that out. But I don't generally learn about these things until after the fact. What else? Julia has something. Oh, that was probably.
Julia was just mentioning, yes, if it wasn't previously federalized by applying for other federal funding, it would be considered federalized before applying to the Division of Housing. I agree. I think that's worth reiterating. Well,
yeah.
I will sorry, go ahead, Brett.
Well, the only other thing I'd say, and this kind of goes back to what we were just talking about a second ago, is if you aren't sure when you're going to apply to Division of Housing, and since we're the gap funder, and if we're the only funder, if it's still 6 months out, then don't overly concern yourself with these regulations yet. Because again, until you apply, the project isn't federalized. I'm saying that while at the same time cringing, because I'm not trying to encourage people to be going up towards near that application date. But you also can't stop your process, right? So if you're going to take ownership of a property for whatever reason, especially in donated properties that are more affordable or something that's at a nominal amount, then, move forward with your project because you're not federalized yet. Now, but if you need the federal funding to secure the property, well, then you're back to the same conversation of, you can't move forward until you secure something. And I don't know any other way around that. But in all cases, always feel comfortable to reach out to me, ask questions, and hopefully I can answer them the best I can. But other than that, I don't have anything else to add. If there's other questions, I'll take them, but I know we're coming up against the 11 o'clock deadline.
So there are no questions in our chat feature, but wanted to thank you, Brett, and thank everyone for attending today's webinar. You will receive an email from me with the materials, with the screenshot of the housing development specialists, the regions they cover, and then also Brett's contact information if you have those in the weeds questions. And just a reminder, in September, we will cover Part 5 income calculations. So be sure to get yourself registered if you are interested in that. Thank you all again and have a great day.
Thanks all.